Three judges who granted ex parte orders over the same subject matter are to appear before special investigation committees constituted by the National Judicial Council to show cause why disciplinary action should not be taken against them. Now, a retired justice of the Supreme Court, Justice Rhodes Vivour, is also worried about this embarrassing trend of conflicting court orders. In this interview, he gives some reasons why this trend continues and what can be done to check it.
There's always a resurgence of this type of things we are complaining about during an election year or close to an election year, because elections in Nigeria, the stakes are too high. They are too high. So what you have, they normally start from the primaries. Nobody agrees he lost the primaries. No politician agrees. So what you have the political party declaring Mr. A the winner. Then Mr. B says he won. He was the one declared on that day. Then you see Mr. C, who did not take part in the election, he says he won, and in some cases being declared the winner. So all these politicians go to court and start trying to get orders that they won. That is where these conflicting orders start. That is where they start. So, wait a minute. It got to a height not too long ago when Justice Rhodes was the Chief Justice of Nigeria and chairman of the NJC. Yes. And many judges were indicted and removed from office, if you remember, in their short panel. Yes. And after their short panel, that was going into the beginning, the early part of this century, several judges were removed for the same thing. But there appears to, I think from about 2010 upwards, we didn't hear much of discipline of judges for this type of things. But now the present Chief Justice has started again to try and nip it in the bud. But it's something that has been going on, and as I said, happens always when there is an election or a run-up to an election. Because at that time, there's a lot of money around.
And so is it a lack of disciplinary action that has, made it to continue?
I guess so. I guess so. Because I could say for about 10 years, we didn't hear anything about discipline on this type of thing. About 10 years. So you couldn't be far from the truth if you say, or if you come to that conclusion. But as you see now, the Chief Justice has indicted 3 or 4 judges, and they have to go before the NJC to explain why
disciplinary action should
not be taken against them.
But why does it appear? Because some people have this perception that the judiciary is always seemingly reluctant to punish its own, both at the bar and the bench, especially when senior lawyers are involved, because of course judges are also lawyers before they become judges. So people have this perception that the judiciary kind of tends to protect its own at the bench and at the bar when senior lawyers are involved.
I don't quite agree. In most of those cases, the petitioners don't come. They don't come. They write petitions and just throw up their hands. But if petitions are followed rigorously, I don't see why, because all these disciplinary measures and what each side says is in the open. Anybody can call for it. Several judges, lawyers have been disbarred. Several have been suspended. Several judges have been sacked, dismissed.
You talked about petition, which is another area that a lot of people have issues with. Why does the NJC wait for a petition when some issues are seemingly glaring that perhaps something has happened that we are seeing this kind of outcomes that we are seeing?
Yeah.
Perhaps money has exchanged hands, perhaps something is untoward has happened. Why does the NJC wait for a petition before it can address issues like that?
There are some matters that you can't address except you have a petition. All right. Now, these 3 judges that have been indicted by the Chief Justice, they didn't wait for any petition. Because those ones, you don't need a petition to start proceedings, disciplinary proceedings. You don't need a petition in that case. It was something whereby conflicting orders were given after the primaries of the APGA in Anambra State.
And it was so obvious.
It was so obvious, everybody saw it. So you call the judges to explain why they gave these orders and things like that. That is different from if you accuse a judge of gratification or things like that. The accuser must come and be confronted by the judge who will defend himself. So that type cannot go on without petitions.
Late Justice Dahiru Mustafa, former CJM, introduced some reforms which were never implemented. One was that the suggestion that the NJC should be relieved of dealing with petitions, discipline, and removal of judicial officers, but focus on formulating and implementing broad policies for the judiciary, while a separate disciplinary body should be set up. That was one of the reforms that he came up with.
I agree with that.
Do you think that's something that could work?
I agree with that, I agree with that.
Why?
Because this body that will be set up will do only that.
Only discipline of
yes,
judges?
But as of now, the NJC does several things. So you could say the NJC has too much on its hands. But if you set up a body only for discipline of judges, I think you will go far.
We will get more results.
Yes, because that body will even go out to look for things that don't come before them.
True.
They're monitoring judges all over the country and things like that.
Another suggestion that has been given for dealing with issues of conflicting court judgments is one that was suggested by the governor of Ondo State, a former president of the Nigerian Bar, Governor Rotimi Akeredolu, who says that the jurisdiction of the Federal High Court, we lawyers say Federal High Court is the same everywhere. So you find people using that as justification to take their cases outside the local jurisdiction to anywhere because it's the same wherever it sits. Do you think that it's time for the Federal High Court to define its jurisdiction, maybe narrow it so that this will curb the excesses of lawyers?
Yes, absolutely. And I agree with
the governor,
His Excellency, Governor Akeredolu. What I think he's saying is that the Federal High Court in every state must, you know, wait a minute, there is one Federal High Court with several divisions. All right. A division of the Federal High Court in Lagos, its jurisdiction must be only Lagos. So it is with every other state. It's not that for a Federal High Court in Lagos to give orders that will bind people in Kano or Kaduna or Lagos, or Port Harcourt or Enugu. So that's where I agree with him. So you won't have this situation that we had in Anambra. There was a case. There was a situation where they went to another state to get an order against what happened in the primaries in Anambra.
But shouldn't the judges that are sitting outside the jurisdiction ordinarily raise it and say, I mean, why are you not before Federal High Court in Anambra? Why have you come to Kebbi or Jigawa? Why do the judges continue to take these cases when they know that it is outside the jurisdiction?
It's true. Cases are assigned by the chief judge. In PDP versus Modu Sheriff, Supreme Court decision in 2017, I gave the lead judgment. And I said there that when a party has its primaries, say primaries for governor of Anambra, or say primaries, all matters on that primaries that is filed should go before one judge in that state. It should never, the Chief Justice should assign the case only to one judge, everything to do with that primaries. Where PDP has its own primaries, APC has its own primaries, the same thing should happen, one judge, one judge.
One judge should handle all of APC,
yes.
Another judge should handle all of
PDPs, yes.
So that the cases are consolidated.
Yes, all there.
Before that,
right.
He is aware of everything.
Everything, yes.
Okay.
Then I went on to say that where the chief judge assigns to one judge, then assigns another one to Judge B, that Judge B should send it back to the chief judge and tell him that all these things are, my lord, probably you made a mistake. All these are to, I said that. And these are things that are hardly followed. And that is the final court.
But if the Supreme Court has said it, why are the other courts
There are
not
many
following?
things the Supreme Court has said that has not been followed.
Why?
I don't know. Take for example, carpet crossing. It is clear in the Constitution that if you cross carpet as a legislator, you must go for a by-election. It's clear. Supreme Court has given decision on that. Who is to implement it? INEC. It's not the Supreme Court should implement it. It's INEC. Where you see you are in the PDP, you win an election, you go into the House, then you cross carpet to APC, and you are staying there. You have to have a by-election. That is everywhere in the world. You want the Supreme Court to come and tell you to get out of there, go to the... It's INEC, it's not Supreme Court.
So there's nothing that can be done to compel INEC to obey that order?
Who will do what? Look, the Supreme Court doesn't have executory powers to force you, or only in cases of contempt can they have that. Once the judgment is given...
But, Milord, isn't that clearly contempt? You're not obeying the order of the Supreme Court.
Somebody must come.
To complain.
Yes, nobody comes to complain. But what I'm saying is that who is in charge of elections and election matters? INEC. If Supreme Court says you must do by-election, that is what you carry. And we are going to do by-election. Look, that's what Supreme Court said. How can Supreme Court come and tell you go? If Supreme Court goes and say no, go out of there, go and do by-election. Who will do it? Will the Supreme Court do the by-election?
So these are the issues.
Yes, those are the issues.
I also hear some lawyers say that judges are like fine wine, and perhaps there's a need to extend their tenure beyond what we already have constitutionally. What do you think?
I support extension of tenure.
You do?
Yes.
So what age?
75.
Why, Milord?
The reason why, you see, if your age is your correct age, at the age of 70, you are still strong. And you see, judges mature with age. The way I look at certain things now is not the way I looked at it 10 years ago. Number one, you are more patient, you are more learned, you are more reserved, you are slow to talk. So if it goes on to 75, I think it's good for the system. In the United States, you retire when you want to retire, anytime. England is 75. And here, with all this, medical has improved tremendously. So most people are very healthy at 70 and above 70.
So you think we should move it to 75?
Yes, but another argument is that there are a lot of people that want to be judges and things like that. So give others a chance. That's another argument.
Which has some merit too.
Yes, it does. It does. How can you stay there till 75 when they are... Yes, yes.
But there was also a time when there was a move to have some lawyers, senior lawyers, come to the bench, the appellate bench, straight from the bar. Yeah. And maybe they would be able to bring their experience from the bar to the bench. And it appeared as if, I might be wrong, below, but correct me, it appeared as if some members of the bench were not quite comfortable with that idea.
That's correct.
We've been queuing up. So why do you want to bring somebody from outside to come and take the spaces? But is it really a good practice?
You know how you look at it. You see, there are few cases of lawyers coming directly to the Supreme Court from the bench, from the bar. People like Justice Elias. People like...
and who prove themselves.
Yeah, people like Justice Nnamani.
Yes.
Those are two I know. And there are cases of High Court judges, usually chief judges, coming direct to the Supreme Court. All right. During the time when Justice Rhodes was the Chief Justice of Nigeria, he says you must go through the court system. You can't come from the High Court straight to the DC. Why? Because we have not read your judgments. We don't see judgments of High Court judges. Although if you can write your judgments, compile them and be bringing them to the NJC to see, maybe that will help. So there are many chief judges that wanted to come direct to the Supreme Court. They said no, so they went to the Court of Appeal. Many of them are there.
But do you think we'll see a time when members
Of course.
senior members of the bar will
course.
come directly to the Supreme Court?
Yes. It's always nice to have all shades in the Supreme Court.